Good morning. This is the second day of the case of Re T. Yesterday, we made a reporting restrictions order which continues to cover these proceedings. The terms of it can be found on the website of the Supreme Court under the case details. I'll invite Ms. Clement for the Secretary of State to continue with her submissions, please.
I'm grateful, my lady. I'm grateful. My lady, I'd like to finish my submissions on issue 3 from yesterday by making 8 key points.
Ms. Clement, before you move on, I wonder if I could ask for your help in relation to a matter that arose at the end of yesterday afternoon.
Yes, of course.
It relates to what I'm referring to as ground 1C. That's the third limb in ground 1.
Yes.
And I understood you to submit at the end of the afternoon that a court can, when the Section 25 conditions are met, exercise the inherent jurisdiction to place in secure accommodation place a child in secure accommodation other than a secure children's home.
Yes.
And I'd just like to unwrap that, if I may, for a moment, because I think there's quite a lot bound up in it. Well, there may be. Assume for this purpose that secure accommodation bears the meaning given by my Lady Black in Re D.
Yes.
That is, accommodation designed for or having as its primary purpose the restriction of liberty. Let's assume that on an application by a local authority under Section 25, the child or young person meets the criteria, but there's no approved secure accommodation available.
Yes.
So Section 25 cannot be the basis of the order. What precisely does the Secretary of State say the judge can do in those circumstances under the inherent jurisdiction?
Well, so the starting point, there is no secure children's home place available. The next question is, where does the local authority want to place the child? If they want to place the child in a registered children's home, that in itself would be providing secure accommodation, or that would amount to secure accommodation, not because it's designed as such, but because that would be its primary purpose. If we are in that very small cohort of cases where a registered children's home would amount to secure accommodation, then we say that the High Court judge can invoke the inherent jurisdiction in that case to place the child in such accommodation if the conditions in Section 100, subsections 3 to 5 are met. In other words, that were that order not to be made, that the child would suffer significant harm.
Well, yes, if the criteria are met.
Yes.
Now, you've built into that answer the notion of secure accommodation as something other than that in the definition offered by my lady in D, because you're referring to it being a secure accommodation not by the design of the accommodation, but by reason of the purpose of the placement.
Well, I do apologise there, my lord. I mean the purpose of the accommodation. And you may recall that yesterday, my lord, I made submissions about the circumstances in which the second limb of that test would be met. We said that the only circumstance in which accommodation is designed as secure accommodation is that which is approved as such by the Secretary of State, the secure children's home. But there may be limited circumstances where a registered children's home falls within the second limb of that test, where the accommodation is provided for the primary purpose of restricting liberty.
Yes,
we do not say that there are many cases where that would arise, because our primary position, as it always has been, is that the only is that the default position is that the only accommodation that is in fact secure accommodation are secure children's homes, but that there may be some children's homes that can satisfy the second limb of my Lady Black's test in Ruby.
Yes, so you're addressing there then that narrow band of possible cases where there is secure accommodation within the D definition, but it's not a children's home.
Well, my lord, it may be a children's home. And indeed, it is more likely to be a children's home than anything else. It is
Let's approach this from a different angle. Now, in the hypothetical situation that I've put, first of all, can the court order that the child or young person be held in accommodation which is secure accommodation, but which is not approved by the Secretary of State within Regulation 3?
Yes.
Right. Secondly, can the court order that the child or young person be held in accommodation which is not secure accommodation within the D definition, but which is nevertheless able to restrict his liberty?
Yes.
And thirdly, sorry, go on.
That is possible because if the accommodation amounts to a deprivation of liberty, if the placement amounts to if the child is deprived of their liberty, then the inherent jurisdiction can be moulded and has been moulded so as to comply with the requirements of Article 5. And we see that from the judgment of Sir James Mumby in Re PS and his judgment in Re AF.
And thirdly, in those circumstances, can the judge order that the child be held in accommodation which is secure accommodation within the D definition, but is not a children's home?
Yes.
That's because it falls within what you say is a very limited situation, but there may be cases where there is secure accommodation within the definition which is not a children's home.
Yes, and in that situation, the court would not be invoking the inherent jurisdiction. The court would be making a Section 25 order. Because there is nothing to prevent a child being placed in secure accommodation, yes, which is not a children's home, under Section 25.
Thank you. So now to go back to, that's very helpful. Now to go back to the first.
Yes.
The criteria are met for Section 25, but it can't be used because there's no approved secure accommodation. You say that the court has the power to order that the child be held in what is secure accommodation within the D definition, but which is not approved within Regulation 3.
Yes. And I said...
Can you tell me why you say that?
Yes, my lord, two points. The first is it may not be the case that they can't be placed in a secure children's home because there isn't a vacancy. We may have a number of other scenarios where the local authority does not want to place the child in a secure children's home because that is not an appropriate placement for them. And Miss Weston will say, as I understand it, that that is precisely this case.
Well, in that case, they shouldn't be making an application under Section 25 in the first place.
Well, my lord, no, because if it is secure accommodation, I think there's an issue of a definition here. We have first secure accommodation. Secure accommodation, it does not necessarily equate to, or only equate to, a secure children's home. Secure children's homes are, if my Lady Black is correct in her judgment, a subset of what amounts to secure accommodation. So you can have a situation where a local authority wants to place a child in secure accommodation under Section 25, but they do not want to place the child in an approved secure children's home. That's my first point. So one could have a Section 25 order in respect of the placement that is not a secure children's home, and indeed that is not a registered children's home. The second point is that one could have an application for an application before the court to place the child in secure accommodation that again is not a secure children's home. One can't make that application under Section 25 if the placement is a children's home because of Regulation 3. So we then say the choice is stark. Either this court says that they cannot be placed in that placement that the local authority has decided is necessary to protect them from significant harm, or the local authority can invoke the inherent jurisdiction as envisaged by Section 100 of the Children Act, and the child can be placed in secure accommodation that is a children's home, because were that order not to be made, they would otherwise suffer from significant harm. And we say, my lord, that that does not cut across the statutory scheme, as Mr. Toomey suggests. We say that Section 100 of the 1989 Act is a part of the statutory scheme. Parliament carefully considered whether it should place restrictions on the use of the inherent jurisdiction. The only statutory bar that it has enacted is that in Section 100, subsection 2. If the conditions in Section 100 are met, then it is part of the statutory scheme.
Sorry, Clement, this is important, and we're not getting all of it, I'm afraid. The line's breaking up.
Do about that. It's the same connection I had yesterday. Perhaps if I just start again, let's hope one gets it this time. We say that it is a question of statutory construction. Did Parliament intend Section 25 to be a complete code and to prohibit the use of the inherent jurisdiction to prevent significant harm to some of the most vulnerable children in our society? That's the position that Mr. Toomey invites you to adopt. We say that was plainly not Parliament's intention. We say one gets to that by looking at the wording of Section 100 itself. The only statutory bar is that in Section 100, subsection 2. If the conditions in Section 100, subsections 3 to 5 are met, the inherent jurisdiction can be invoked. That is part of the statutory scheme. We also see that from the background material that we looked at yesterday. And we say that that was the conclusion that Sir James Mumby reached in the Re X and Y case, and that conclusion was clearly correct. My lady, I do apologise. I was halfway through that submission. I wanted to finish it.
I'm glad you did, and I'm sure that Lloyd Jones has probably got some more questions for you as well. But I just, before we lost it, wanted to pursue the idea of what Parliament intended. Another possibility is that Parliament intended that there would be sufficient approved placements to cater for the children who satisfy the criteria. So I'd be interested in what the Secretary of State has to offer us about that.
Yes, well, my lady, if one looks at Z County Council and M, it's at tab 95, page 3710. This is a helpful summary of the categories of children who might need secure accommodation. It's paragraph 24 on page 3715 of that case.
Paragraph
24, page 3715.
Thank you.
So the first category is, as my lady suggested, those children for whom a local authority considers that a secure children's home would best meet their needs. That's the most appropriate placement for them. But the second category is the first bullet point in this list. The professional view is that on a welfare basis, the environment and care regime offered within a residential care home, together with the deprivation of liberty order, meets the safety and welfare needs of that child more effectively than secure accommodation under Section 25. There might be a variety of reasons for that. The child might have already been placed in secure accommodation and that placement's broken down. The secure care home has terminated the placement, and it's plain that the child's needs are not being met there. One then sees the second bullet point. The local authority might consider placement within a residential unit with DOLS restrictions to be the more proportionate approach. With the mind to the nature of the current approved secure estate and the environment it offers, local authorities tend to regard secure accommodation as a measure of last resort, and the residential unit with bespoke restrictions approved by a court is perceived as less interventionist. That's the third. The next category is the local authority might seek to invoke the inherent jurisdiction as part of an exit strategy from secure accommodation. It forms part of a step-down transition from a secure children's home, essentially. So the child's been there, the child's condition has improved somewhat, it's not proportionate to keep them in that particular accommodation at that time, but it may still be a move to a different form of secure accommodation, but where that is less restrictive. So it's not only the case that my lady puts to me that the only circumstances, the Parliament envisaged, the only circumstances in which secure accommodation needs would be met would be in a secure children's home. If that were correct, then with respect, your ladyship's judgment in Re D goes too far, and the only category of secure accommodation is in fact that designed as such, namely a secure children's home. My lady, some of the 8 points I was going to make I've already covered, but with the court's indulgence, if I could just run through those 8 points.
I'm sorry for interrupting you. You had a barrage of questions this morning. I was just interested in the definition of secure accommodation in Re D.
Yes.
Which is designed for having as its primary purpose restriction of liberty. One finds that page 1160, for instance. I was just wondering whether or not the context of section 25(1)(b) should add to that definition, because and whether the test should be designed for or having as its primary purpose the restriction of liberty, but must also include features substantially minimizing the risk of injury to the child or to other persons. And those raising the question now, it may be that you'd like to have a think about that, because it encompasses another feature of Section 25, and for myself personally, I'd be grateful for some written comments about it, if that was available.
My Lord, I would certainly be willing to do that. That does reflect the submission I made yesterday in terms of what is meant by accommodation, the primary purpose of which is to restrict liberty. And you may recall that my submission yesterday is that that is only likely to encompass accommodation that is related to the criteria in section 25(1)(a). So I would adopt what your lordship says there, because the criteria in section 25(1)(a) are, I say, a clear indication of what Parliament envisaged was meant by secure accommodation in the first place.
Okay, the next question is what you're arguing for are different levels of deprivation of liberty. And so if you have deprivation of liberty under the inherent jurisdiction in relation to some lesser degree than secure accommodation, why is it, or should the criteria mirror section 25? And if not, what other criteria should apply?
My lord, I don't say the criteria should mirror section 25. They only mirror section 25 if what the court is doing under the inherent jurisdiction is placing a child in secure accommodation. If the court is not doing that, but is nevertheless still otherwise depriving a child of his or her liberty, then what the court is doing is saying, is it lawful for the local authority, for the state, to deprive the child of his or her liberty? And therefore the criteria that apply are those that are set out in Article 5 of the Convention itself.
Thank you.
My lady, I'm conscious of the time. It is 10 and I haven't got beyond the 2 key points I wanted to make on issue 3. I also need to make submissions on Article 5 and make a few points in terms of consent. I'm in your ladyship's hands as to whether I should do that in writing or whether you would like me to continue for a short period this morning.
Well, I think the questions that have been put to you have been important ones on a central feature of the case. I don't know if there are any more questions on that aspect of the case before we move on. Why don't you see whether, to what extent, you're going outside the bounds of your written case with regard to the other matters in any event? And then give us the headlines and see how we can go in the next, say, 10 minutes. And then we can take stock at that point.
I'm grateful, my lady. The 2 points raised by Mr. Toomey have been outlined on Article 5, have been outlined in our written case, but he did put them slightly differently yesterday. It's also important to note on Article 5 that there have been important points raised by the Children's Commissioner for England on Article 5, asking this court to consider and apply recent Strasbourg case law that we've not even looked at yet. Mr. Toomey didn't turn those up yesterday. I haven't had the opportunity to address those in writing because the Children's Commissioner filed her intervention after we filed our written case. So I would appreciate an opportunity to respond to those submissions in writing because they are important and it could have important consequences for the development of Article 5 in domestic law.
What I suggest we do for the moment, I can see Lady Arden wants perhaps to ask you something, but what I suggest we do for the moment is to concentrate on the points that have been raised by the parties, and then we'll see where we go with regard to the points raised in the interventions towards the end. But you concentrate on the direct central points for the moment. Lady Arden.
Lady Arden, you're on mute.
Is that okay now?
Yes, I can hear you now.
Perfect. It's just that the cases I think you're referring to are those where the court had said there must genuinely be educational provision and a place for it in developing the Konya-Arski. But that's a whole new area where we have no facts. And I just wondered to what extent we could possibly deal with that in a meaningful way.
My lady, I agree with that. The Children's Commissioner asks you to make findings about the meaning of appropriate, the way the Strasbourg court has approached appropriate. That is important. The Secretary of State would want to respond to that if this court were going to address those points. The same in terms of the intervention by the Children's Commissioner for Scotland. We say that has no connection to this case. This child was never placed in Scotland. There was never any consideration of it. But again, if this court is intending to address those points, we would want the opportunity to deal with that.
Well, shall we leave it in that situation then, that you carry on with the central points which are raised by the parties, and if we need assistance, we'll let you know.
I'm very grateful. In terms of what Mr. Toomey said yesterday, first he said deprivation of liberty cannot be lawful if the placement is in an unregistered children's home. One looks at Article 5 itself, and what Article 5 says is that there has to be a deprivation of liberty has to be in accordance with a procedure prescribed by law, which the Strasbourg Court has interpreted as meaning must comply with the requirements of national law. He also says that the substance of Article 5, essentially the Article 5.1d condition, that detention of a minor must be by lawful order, and we need to address that as well. So in terms of the substance, detention of a minor by lawful order, I invite the court to look at the decision of Benham and UK, tab 96, page 3722, and paragraph 42 of that judgment. And Mr. Toomey accepted yesterday that an order is valid, a court order is valid, unless and until it is set aside. But in any event, I say it is in accordance with national law for the local authority to place that child in an unregistered children's home in the following circumstances. First, it would fall within the terms of section 22C6D of the Children Act. That's at page 844. It must comply with the relevant regulations. It says 22.6C. It's subject to placement in accordance with other arrangements which comply with any regulations made for the purpose of this section. That regulation is Regulation 27, the care planning regulations. It's found at page 2035. And it must also comply with the President's practice guidance, which is at tab 129, page 5182, which makes clear that if it is a placement in an unregistered children's home, that establishment must apply for registration. The court will monitor the application for registration and continue to review the placement in the event that that application is not successful. That, I say, does comply with national law. In terms of his point on procedure prescribed by law, as I understood it yesterday, the entire basis of this submission is that the use of the inherent jurisdiction is too uncertain. It now appears to be common ground that prescribed by law can mean all of the law in the member state, in the contracting state, including the common law. We say that must be right. It follows from the Sunday Times case. That's the supplementary bundle, tab 14, page 311. And that's paragraph 46, paragraphs 52 to 53. We see Strasbourg confirming that position in the context of deprivation of liberty and Article 5, in the case of Steele and UK, supplementary bundle tab 13, page 262, and I invite the court to read paragraph 35, 51 and 55. Mr. Toomey says it's not law because one doesn't know what tests the court will apply under the inherent jurisdiction. We say it is clear, and this is the point I think I made earlier to my Lord Stevens, is that if one is using the inherent jurisdiction to place a child in secure accommodation, the court will mirror the Section 25 threshold. That was clearly stated to be the position by the Court of Appeal in this case, and by the Court of Appeal in INRI B. If one is otherwise seeking authority for a deprivation of liberty, the court is moulding the inherent jurisdiction so as to comply with Article 5, and we see that from REPS, tab 12, page 1270, at paragraph 16 to 22, and REAF, tab 15, page 1310, paragraph 45 onwards. So that's what I say in response to Mr. Toomey's submissions on Article 5. The final point on consent, which I will make as briefly as I can. If the placement is secure accommodation, big if, then we say the President was correct to say that consent is not relevant under Section 25. It's not relevant under Section 25. If the inherent jurisdiction is being moulded to reflect Section 25, then it is not relevant there either. That's not to say that a child's wishes and feelings are irrelevant. Of course not. They are taken into account in the statutory scheme, for example, in Section 22.4, Section 22.5, and one finds that at page 839 of the bundle. If the placement is not secure accommodation, then one only needs a court authorisation for it if the child is being deprived of liberty under Article 5. A child will only be deprived of liberty if the 3 limbs of the Stork test are met. And the second limb is the absence of valid consent. We say that in principle, a Gillick competent child can provide that valid consent. But whether she does, one has to look, whether she is in fact consenting, means one has to look at all the circumstances, what the child says and what the child does. And there are 3 cases I'd invite your ladyships and your lordships to read on the issue of consent. The first is Stork itself, tab 106, page 4109 and paragraphs 74 to 77. The second is Emma and Ukraine, tab 101, page 3916, paragraph 75 to 77. And the third case is another case called In Re C. It's a different one, tab 69, page 3121. And this is an example of a Gillick competent child being found to be capable of consenting to confinement that would otherwise be a deprivation of liberty, and the court looking at whether on the facts the child had in fact provided that consent. My lady, those are the key submissions that I wanted to make. In terms of whether anything in writing is required, my Lord Stevens asked me to consider the point he put to me about the definition of secure accommodation. I also haven't run through the 8 key points that I wanted to make right at the outset, which is a summary essentially of what I have said. And I believe I can fit that onto one side of A4. And it might be of assistance if we do that in writing rather than me trying to go through it now. And then I'm in your ladyship's hands as to whether the court intends to address the points made by either of the other interveners. If the court does intend to do that, then we would appreciate the opportunity to deal with those points in writing.
Lord Lloyd-Jones has got a question for you, I think.
Yes.
Thank you, Ms. Clement. It would assist me at least. I don't know about my lady and my lord. If you could also produce in writing a response to the points made by the Children's Commissioner for England in relation to the Strasbourg cases.
Yes.
And in addition, if you could set out in writing the answers to the questions which I fired at you at the start of this morning.
Yes, of course, my lord.
Thank you.
And just when I add to that list, could you also address the Children's Commissioner's points on the safeguards. That's paragraph 19 and 17 and 19.
Yes, of course. I think both the Children's Commissioner and the Association of Lawyers for Children also made points on procedural safeguards, and I'm happy to address both of those in writing as well.
That would be helpful.
Was there anything else I should add to my list?
I think, of course, once you've done your reply in writing, there may be other people who want to say something as well. So I wonder if you could all have a discussion about how that's going to be handled so that we don't have to start giving detailed directions and taking up more of this morning's hearing on that.
I'm very grateful.
We are not inviting 50-page submissions on these matters. We are inviting a very short, pithy response to each of the questions. Brevity does seem to be quite useful.
Yes, I'm
when
grateful.
It comes to post-hearing submissions.
I'm grateful. My lady, unless there's anything else, those are our submissions.
Thank you very much indeed, Ms. Clement. So I think it's over to you, Mr. Hopkins, isn't it?
Yes, thank you, my lady, my ladies, my lords. I appear along with the Millennium Friend, Mr. Rees, on behalf of Cafcas Cymru and the Welsh Government or Welsh Ministers. My lady, Cafcas Cymru is, of course, the operational arm of the Welsh Government responsible for fulfilling Cafcas functions in Wales. And you will know from the Court of Appeal judgment that Cafcas Cymru was joined as a respondent in the Court of Appeal. The Welsh Ministers or Welsh Government was joined as an intervener by an order of this court on the 16th of September to enable the wider governmental position be advanced in view of some of the wider issues arising in particular from ground one of the appeal, as they relate, of course, to Wales as much as they relate to England. My lady, my lords, by way of very brief opening preamble, the Welsh Government is very concerned about, and I've set this out at paragraph 81 to 86 in our document, page 276 onwards, provision for children and young people in Wales with very complex and challenging behaviours. And I referred within that section of the document to extracts from two speeches from the relevant minister, indicating that the focus within Wales has been on the provision of improved services and expenditure relating to that, to avoid the need, ideally, to have recourse to the last option of secure accommodation. So it's very much a concern at the highest level within Wales as well, and nothing in my submissions is designed in any way to undermine that point. In terms of the structure of my submissions, as foreshadowed by Ms. Clement, I'm going to briefly sketch out and amplify some of the Welsh law perspective in this case in terms of both primary and secondary legislation, and to take my ladies and my lords to some of the definitions within Welsh legislation. I'm going to refer briefly to the regulatory framework within Wales insofar as that's necessary, and then also make some brief submissions in relation to Camp 1 and in relation to Ground 1 and 2 in the appeal. So turning, my ladies, my lords, then to the context of this particular case. The court, of course, knows that the appellant was a Welsh young person in the care, significantly, of course, of a Welsh local authority at the time the two orders that are now the subject of appeal were made. Social care, health and education were devolved to Wales in Spartacus 2006. And the position is that Part 3 of the Children Act, where, of course, Section 25 can be found, and the regulations in relation to Section 25 have been disapplied to Wales and replaced instead by the Social Services Wellbeing Act 2014, which has been enforced since the 6th of April 2016, together with a number of regulations under that Act and various supporting codes. Most parts of the Welsh Act, if I may use that as a short form description for the Act I've just mentioned, most parts of the Welsh Act have a relevant code, and local authorities, Welsh local authorities that is, must follow the relevant codes. So some fundamentals, very briefly, if I may, my lady. Part 1 of the Welsh Act sets out the concept of well-being, which seeks to address all potential needs of an individual, including a child and young person, physical, mental, domestic, and so on, and also incorporates in relation to children, of course, welfare in the sense of its meaning within the Children Act 1989. Very briefly, there are a number of overarching duties within Part 2 of the Welsh Act, including the duty to have due regard to the United Nations Convention on the Rights of the Child. A theme within this legislation and the regulations and the code is the importance of listening to the views of children and young persons, and we see that within one of the overarching duties in Section 6, subsection 2A of the Welsh Act. But can I turn to Part 6 of the Welsh Act, because that's the section, that's the part of the Welsh Act that deals with looked after children and accommodated children. And there is a specific code attaching essentially to Part 6, which applies and which, as I've indicated, Welsh local authorities must follow. Now, many aspects of the statutory provision within Part 6 of the Welsh Act are mirrored, of course, within provisions in the relevant part of the Children Act. And I'm certainly not going to go through all of those this morning. But can I just deal briefly one or two important sections within Part 6 of the Welsh Act. Section 74 of the Welsh Act, and that's at tab 33, deals with the definition of a looked after child, because of course the appellant was at all material times a looked after child. And essentially, you will see very familiar territory there. The appellant was a looked after child for the purposes of the authority that you're concerned, the local authority you're concerned with, as she was a child in the care of the respondent local authority at all material times. Section 75 of the Welsh Act provides in a mirror fashion the general sufficiency duty on Welsh local authorities in terms of the provision of accommodation for children that are looked after. So as the case in England, the duty falls upon local authorities to put in place a range of accommodation to meet the needs of children in its area. And my ladies and my lords, between paragraphs 260 and 265, I've set out a number of general and specific duties on Welsh local authorities in relation to children under the Welsh Act, which is of course supplemented by the relevant regulations. And it's the Care Planning, Placement and Case Review Wales Regulations 2015, which I've set out in some detail in my document, which imposes a number of duties on Welsh local authorities in relation to looked after children. And just digressing for a moment, the effect is as follows: that there were, at all material times in this case, a significant number of duties imposed upon the relevant local authority in relation to the appellant, in relation to her as a looked after child, regardless of issues about secure accommodation for a moment. May I touch then briefly upon the, by way of an overview, of the regulation of social care in Wales. I don't propose to go into the nuts and bolts of regulations in any detail at all, but my ladies, my lords, the relevant act dealing with regulation is the Regulation and Inspection of Social Care Wales Act 2016. In relation to that at section 2 sets out the ways in which there is a regulated service covered by that act. And if I can take my ladies and my lords, to Section 2, subsection 1 of that Act. That's at tab 136.
Hopkins, we're all working off electronic bundles, so the page reference would be more helpful.
Oh, forgive me. I'm so sorry. Forgive me.
It's 5328.
I'm very, very much obliged. In relation then to regulated services under the Act, in Section 2, subsection 1A, we have the inclusion of a care home service. And then at Section 2, subsection 1B, we have a secure accommodation service. Then within paragraph 1 of Schedule 1 of that Act, we then have the meaning of the care home service. Yes, my lord.
I'm sorry, if I could have the page number, I'd be very grateful. Sorry.
Forgive me, would your lordship bear with me for one moment?
If it helps, Mr. Hopkins, it's 5330.
I'm very grateful. But a slight difficulty with my access to my electronic bundle at the moment. I'm so sorry.
Don't worry.
I'm very grateful to Ms. Clement assisting the way that she is. In terms of the definition of a care home service, this is the provision of accommodation together with nursing or care to place in Wales to persons because of their vulnerability or need. I'll come back to that in a moment in relation to the definition of a children's home in Wales. And then secure accommodation, as I've indicated, is another regulated service under Section 2, subsection 1B of the Act. And that's defined as the provision of accommodation for the purpose of restricting the liberty of children at residential premises in Wales where care and support is provided to those children. Then, in terms of the definition of a children's home, that is set out... Sorry, my lord.
Where do we find the definition of secure accommodation service?
That's at paragraph 2 of Schedule 2 of the Regulation of Social Care Act. 5332.
Yeah. Thank you very much.
Then, my ladies and my lords, in terms of the definition of a children's home in Wales, we find that within Section 197 of the Welsh Act. I'll give my ladies and my lords the page reference in a moment, which defines a children's home. It's at tab 33. Bear with me for one moment, I can give you the page reference.
It's 2008.
I'm very grateful. Just to take my ladies and my lords through that. Section 197 of the Act defines a children's home or cartref plant in Welsh as follows: a children's home in England within the meaning of the Care Standards Act 2000, in respect of which a person is registered to Part 2 of that Act, and a place in Wales in respect of which a person is registered under Part 1 of the Regulation and Inspection of Social Care Wales Act 2016 to provide 1. A care home service within the meaning of paragraph 1 of the schedule to that Act, as I've taken my lords and ladies to, but then wholly or mainly to children, or 2. A secure accommodation service within the meaning of paragraph 2 of schedule 1 to that Act, which again I've taken my lords and ladies to. Just very, very briefly, there are 2 sets of regulations under the Act dealing either with the registration of the relevant service and also a separate set of regulations dealing with the actual regulation of such services. And the regulator within Wales is now known as the Care Inspectorate of Wales, the equivalent effectively of Ofsted in terms of regulation of children's homes and secure accommodation units in England. And in terms of, again, very briefly, the way in which regulation operates in Wales, I've set out in paragraphs 60 to 72 of my document, which is at page 272 onwards in the bundle. The steps that would be taken in Wales by the regulator in relation to a number of potential scenarios, which I don't propose to take my lords and my ladies through now. It's in the document. Now, of course, the reach of the Care Inspectorate of Wales is, of course, limited to Wales. But as you've read in the written case on behalf of the respondent local authority, if Care Inspectorate of Wales becomes aware of the placement of a child in unregulated accommodation within England, there are clear lines of communication between the Care Inspectorate of Wales and Ofsted in relation to the passing on of such information cross-border, as it were, between the relevant regulators. So may I turn to secure accommodation? And may I take my lords and my ladies to the statutory scheme insofar as it applies, certainly within Wales, in terms of secure accommodation being located in Wales, the relevant provision is at section 119 of the Welsh Act, which is at tab 5, at page 995. And, my lords and my ladies, you will of course see by comparative analysis, say for some grammatical and consequential differences, the provision at section 119 mirrors very closely section 25 of the Children Act in terms of the provision. And in terms of the sort of territorial reach, as it were, of section 119, for the avoidance of any doubt, as I've indicated, it's limited to secure accommodation that's located within Wales. So it follows that the relevant section in terms of secure accommodation is section 119, where any application is made by a local authority, be it Welsh or English, where the proposed placement is approved secure accommodation in Wales, and that's, again, regardless of the location of the court centre dealing with the application. Conversely, if the proposed placement is in England, then section 25 applies to a Welsh local authority or an English local authority, again, regardless of the location of the relevant court centre. And very briefly, yes, my lord.
Sorry, just while we have section 119 open, do you consider that the definition of secure accommodation should also include a reference to the section 119 1B?
It does, my lord, in the relevant regulations, which I'm going to come to very shortly, the secure accommodation regulations that apply in relation to section 119.
Well, do you think then that the test for secure accommodation in Ray D should be adapted to include those additional words?
My lord, I certainly see the force in that, yes. May I just very briefly sketch out where we see in practice the different acts apply insofar as this case is concerned? You'll have seen from the statement of information that, in fact, the appellant was placed in secure accommodation in South Wales in accordance with section 119 of the Welsh Act from April 2016 to June 2017. There was then an attempted placement at a non-secure residential unit in England on the 16th of June 2017, followed then by a short period in secure accommodation pursuant to section 25 in England, before a further order pursuant to section 119, when the appellant was back in secure accommodation in South Wales from July 2017 until the move to the first placement that my lords and my ladies are concerned with from July 2017. But then moving on, if I may, then to the relevant regulations that that apply under the Welsh Act, and they're set out at tab 6. And if I can take, and the page reference for that is 997. And you see within Regulation 1, again, a further definition of secure accommodation, clearty diogel in Welsh, unless the wording indicates that it's being in as restricted to accommodation in Wales, means accommodation which is provided as follows. A, in Wales for the purpose of restricting the liberty of children to whom the criteria in paragraphs A or B of section 119 subsection 1 of the Act apply. B, in England for the purpose of restricting the liberty of children to whom the criteria in paragraphs A or B of section 25 subsection 1 of the Children Act apply, or C, by a secure accommodation service in Scotland as defined by the relevant Scottish Act. I can very briefly then take you through some other important parts of the regulations. My document sets out in summary the regulations 2 to 7 at paragraph 43, page 268. I don't propose to take you through them, but if I can take you to regulation 8 of the Welsh secure accommodation regulations. Which is at 1006. Which deals with placement in a regulated setting. A local authority may only place a looked after child in secure accommodation. We see there in the circumstances set out. A, provided in Wales by a secure accommodation service in respect to which the provider is registered. B, in a home in England which is registered under Part 2 of the Care Standards Act as a children's home, providing accommodation for the purposes of restricting liberty. Or C, provided by a secure accommodation service in Scotland. So that imposes on Welsh local authorities the requirement to place a looked after child in secure accommodation in the way set out in that regulation. Briefly, regulations 9 to 12 deal with reviews and records. Don't propose to take my laws and latest to that. It's regulation 13, which deals with the requirement for Welsh ministers to approve any application, and that is at page, forgive me, 1011. Welsh ministers to approve, again in a mirror fashion, any application for the placement of a child aged under 13 in secure accommodation. And then regulation 14 over the page, forgive me, sets out, again, in very similar terms, in same terms, I should say, in relation to the English regulations, children to whom section 119 does not apply, and we see there the circumstances, any child detained under the Mental Health Act, subject to a child assessment order, who is, or a child who's remanded to youth detention. If I can then take my lords and ladies to regulation 16, which then deals with children to whom section 119 has effect, be it subject to modifications. And that again is familiar territory, includes children other than those looked after by a local authority who are accommodated by local health boards, national health service trusts and local authorities in the execution of education functions. Part 6, the Code of Part 6 has a specific section relating to secure accommodation as well, which local authorities in Wales must follow at tab 43. I can give my lords and ladies the reference for that in a moment. So it follows that a Welsh local authority cannot lawfully place a child or young person in unregulated secure accommodation. Such would be an unlawful placement in either England or in Wales. Can I then deal with the Welsh equivalent of what's been described as unregulated placements? If I can take my lords, my ladies, then to section 81 of the Welsh Act, which is at tab 33, which is at page sorry. Yeah, page 80, section 81. 1992.
I think it's 1989, Mr. Hopkins.
Oh, I'm very grateful. At section 81, subsection 6D, this section deals with various placements the various placements that a looked after child can be placed in a hierarchy. But at section 81, subsection 6D, there's reference to other arrangements, placements amounting to other arrangements, which essentially do not then require regulation by the Care Inspectorate of Wales, but Regulation 30 of the Care Plan and Placement of Children Regulations Wales sets out the duties on local authorities before placement in such unregulated placements, which is essentially the Welsh equivalent of the English placement in section 22, subsection 6D. What the code, there's a relevant section to the code in relation to such placements. Part 6 code indicates that such placements, though, are appropriate for those young people aged 16 years or older. Position is in terms of the use of such placements for purposes of secure accommodation or any form of deprivation of liberty order. Certainly the Care Inspectorate of Wales would require the relevant placement to apply for registration in accordance with the practice guidance. So if I may then move on to briefly deal with the Lord, my ladies and lords, bear with me for one moment. Yeah, if I move on to deal with the status of the...
Sorry.
Lord.
I think Lord Steve's got a question.
Yes, my lord.
I have been following these important legislative provisions, but my essential is, if we could have a pithy answer, what difference does it make? What are we to take out of it that makes a difference?
Well, my lord, I'm not sure that there is any material difference to be taken out of it. It's important that, of course, that it's clear that the duties that apply to a Welsh local authority placing a child outside Wales apply as a consequence.
Thank you very much.
Briefly, in relation then to the status, as it were, of the first placement that the court is concerned with, it certainly appeared to those acting for the Welsh Government and Cafcas Cymru that it amounted to a children's home within the meaning of the definition that I've set out to the court. And indeed, of course, there was an application pending the court was informed about, which must have related to an application to be a children's application for becoming a children's home. In relation to whether it was accommodation that was designed or provided for the restriction of liberties, plainly it was not designed for that purpose, plainly not. but it seemed that I should emphasise that we also agree that there was no finding at all by the court in relation to the status of that first placement. But it did seem arguable to those acting on behalf of the Welsh Government that the primary purpose was the restriction of the child's liberty. And whilst it's always important to exercise caution before applying factually the circumstances of different cases, we are mindful of Lord Justice Baker's application of the definition of secure accommodation in RED in that particular case to the accommodation that was provided for that young person. And he came to the conclusion that it did amount to secure accommodation, and there certainly appeared to be certain similarities between the accommodation and the restrictions relating to the regime of care for that young person to the young person that this court is concerned with. And if I then turn to the submissions in relation to ground 1 of the appeal, we respectfully support the submissions advanced on behalf of the Secretary of State. I'm conscious of the time. There's little we can say to improve upon them. In relation to ground 1A, we respectfully agree and support the submission that the statutory bar pursuant to Section 100 subsection 2D of the Children Act 1989 does not apply in this case for the reasons already set out. We also submit that the relevant local authority was not seeking a power to determine a question which had arisen in relation to an aspect of parental responsibility in relation to the appellant. Rather, the local authority was seeking for the court to determine whether it would be lawful to deprive the appellant of her liberty in accordance with the proposed plan for her. We agree and support the submission that the order made by Miss Justice Mostyn on the 23rd of January 2018 was specific in relation to specific accommodation, the first placement the court is concerned with, and once again specific in relation to the second placement under the order made in March 2018. When the case was first before the court on the 23rd of January, it was then adjourned initially to the 6th of June. However, as a result of the breakdown of the first placement, it came back before the court again on the 22nd of March. So here we see in action the court directly reviewing the situation as the circumstances changed on the ground. And once again, on at the hearing in March of 2018, the court was once again at that time asked to approve the deprivation of the appellant's liberty and to determine whether it was lawful for her liberty, for the deprivation of her liberty at that time. And it was so satisfied and made then the second order in relation to the second placement. And the references for the two orders are 412 and 414 respectively in the bundle. And at that point, when the second order was made, the case was due to be heard again by Miss Justice Mostyn on the 6th of June. Another direct example of the court directly reviewing the situation, but then that hearing was subsequently vacated due to the Court of Appeal case. And we respectfully support the comprehensive analysis that's been set up by Ms Clement in relation to the purpose behind the imposition of the statutory bar in Section 100 subsection 2D. Again, conscious of the time, briefly in relation then to ground 1B, we submit that the inherent jurisdiction that was deployed in this case was in accordance with a procedure prescribed by law. And we, if I can perhaps deal with this aspect very briefly, we too would wish to consider, if necessary, very short written submissions in relation to the submissions advanced on behalf of the Association of Lawyers for Children and the Commissioner for Children in England in relation to their recommendations. And ground 1C, again, we share the submission, we support the submission that the inherent jurisdiction in this type of case does not cut across the statutory scheme. We say that the position in this case was a very real example of the inherent jurisdiction acting as a safety net, that without access to the inherent jurisdiction in the way that it was implemented in this case, it is inevitable that the appellant would have been exposed, we say, to significant harm. And that, we say, would be the position in relation to other children and young persons in her position. So very briefly, again, conscious of the time, move into ground 2. If I can briefly, very briefly, revise the way it's put in our written document, because we've referred to in that document the Court of Appeal conclusion that the child's consent was not a precursor to jurisdiction. We can add to by saying, but that the Court of Appeal did not hold that the child's consent to confinement in a non-statutory placement was irrelevant. Very briefly, nothing I'm about to say is intended to lessen in any way the importance of listening to the views of children and young people in Wales. As I've indicated already, the importance of doing so is a theme that runs throughout the Welsh Act, regulations and codes. As I say, nothing is designed to undermine that. But can I just deal with this particular case first of all, because there was plainly an issue. There was certainly no issue, we agree entirely, there was no issue as to the appellant's capacity to understand the notion of deprivation of liberty. And she plainly had the capacity to agree to her deprivation and to understand what it meant in a real meaningful sense. However, plainly the judge at first instance had concerns about the quality of consent expressed by and on her behalf at the hearing in January 2018, and even more so at the second hearing in March of 2018. And of course, ground 2 of the appeal in the Court of Appeal was that the court was wrong to find the appellant did not consent to the restrictions. But turning to the implication of that, we agree with the local authority in its submission that it's not appropriate to extrapolate from the Court of Appeal judgment the submission that the consent by a person in the position of the appellant facing the application that she did was irrelevant. We submit that it's clear that welfare is part of the evaluation of any application for an order pursuant to either Section 25 of the Children Act or Section 119 of the Welsh Act, as indeed was made clear by the Court of Appeal at paragraph 74 of the judgment at 406. And it follows that there is a mirror, in terms of a mirror approach in terms of applications under inherent jurisdiction. There plainly is a welfare evaluation as part of the determination of any application under the inherent jurisdiction. The Court of Appeal is silent as to whether there is a need to conduct a proportionality evaluation, but certainly from REB it's clear that of course that is also necessary. But within the welfare evaluation, the views of a child or young person are plainly taken into account as part of that evaluation and as part of determining whether deprivation is necessary. But of course the views are not determinative. And we see in the closing section of the submissions by the Association of the Lawyers for Children and the Commissioner of Children in England, submissions that are consistent with these submissions. So, ladies, my lords, conscious I'm just over now my time. Unless I insist any further, those would be our submissions.
Mr. Hopkins, you've actually done remarkably well, because you have had your time cut short, rather. So thank you very much indeed for that. I don't know whether anybody has any questions. I don't think so, but thank you very much. And of course, we got your written submissions as well.
Thank you, Melody.
Thank you. We are going to need to have a break at some point. The question really, I think, is whether we have that before Miss Weston or afterwards. I would be inclined to say let's hear Miss Weston's submissions first.
I'm happy to proceed, my lady.
And then we'll take a 5-minute break at the end of that, and hopefully that can be accommodated in Mr. Toomey's time. Thank you very much.
I'm grateful. My ladies, my lords, I represent Caerphilly County Borough Council along with Ms Amanda Muse and Ms Lindsay Sandbrooks Wright of Council, and also Ms Bethan Manners, solicitor. As the court will be aware, it falls to me to deal with the facts in this case, and it may be helpful just to have a quick review of where to find the facts on which the principles, so far as relevant as raised in this case, fall to be decided. The facts are to be found primarily in the Statement of Facts and Issues, EF 133 to 141, and the detailed chronology which begins at EF 153, which I'll come back to in my submissions. The steps taken by Caerphilly to find an appropriate placement are set out in more detail in Caerphilly's written case at EF 220 to 228, and in the second statement of Gareth Jenkins, exhibiting the care plan and the contract as a means of illustrating to the court issues of fact relevant to the question of what form of accommodation both placements were, the first at Serenity and the second at Rowan House, which I'll come back to. And then,
I think, Miss Weston,
yes.
We are not going to be able to make any findings as to what nature of the placement these were. And so, as I think we said at the outset, you're going to have to find a way around that in making your submissions.
Yes.
Just bear it in mind.
Yes, yes, I understand that. I mean, for the avoidance of doubt, it's it's Caerphilly's position that there was no finding by the court at first instance on what form of accommodation it was. Some of the language in both that judgment, those judgments, the two judgments by Bossinger, and the language used by the Court of Appeal implies that there was some kind of equivalence of accommodation, but it's going to be my submission that when the court was dealing with those factors, they were really dealing with the equivalence of the threshold criteria being met and not the nature of the accommodation provided pursuant to the orders. So for all those reasons, it doesn't surprise me that the court's not in a position to make a clear finding. In any event, I have to be limited to what my client thought they were doing at the time, rather than looking back in hindsight, particularly because the two key authorities that we're all relying on for the purposes of deciding what the primary purpose was post-date the decisions and the applications in this appeal. So for all those reasons, I quite understand why the court's taking the position it does, and I will endeavour to tailor my submissions accordingly. So, but I do have some general submissions to make about the approach taken by the local authority in this case, which is set out in the undisputed documents relating to the facts. There is a further chronology act, which is in the core bundle at EF 676 to 681, that was a chronology which goes back a bit further in time, may be of assistance to the court. It's there if the court needs it. Secondly, then, if I could introduce Caerphilly to the court by reference to the first statement of Mr. Gareth Jenkins at EF 599. And from that, from paragraph 2 of that statement, which is at EF 600, we can see there that Caerphilly has a population estimated to be 180,500. It's the 5th largest authority in Wales. And then, more relevantly, in 2017, Caerphilly made 90 applications to the Family Court for children and young people, 3 applications for Section 119 placements. Give an idea of figures involved. I don't know if the court just wants to read through to the end of that paragraph. It's a useful introduction to the difficulties that Caerphilly faces in practice when looking at demand for secure placements. And then in this short statement at paragraph 10, it's chimes with the observations made by both the ALC and the Children's Commissioner, and indeed by the Welsh Government in its written case, that the additional issue experienced by Caerphilly in the context of this case and with other young people is the lack of suitable move-on accommodation when a period of secure comes to an end. So that is really identifying a need for a category of accommodation which has some aspects of restrictions of liberty in a step-down sense, in a phased or graduated sense. And this chimes with what I would respectfully suggest as a theme in the both the interventions of the ALC and in the written case of the Welsh Government, which is that the statutory scheme has, as time has gone on, become less able to accommodate the relatively sophisticated approach and child-centred approach to the provision of accommodation tailored to the needs of the particular child. And I make that submission not only in the context of the particularly complex needs that arise in this case, but also generally in that certainly applying the Welsh framework and guidance, the fundamental essence of the approach to provision of accommodation for children is not to fit the child to the available accommodation, but to ensure that the accommodation provided is fitted to the needs of the child. So what Mr. Jenkins makes clear in paragraph 10 at EF 601 is that because of the difficulties in accessing and obtaining accommodation, able to provide the sophisticated degree of therapeutic intervention in a nurturing environment that the appellant needed in this case, it was necessary to commission a bespoke placement, and he sets out the circumstances in which that became apparent at paragraph 10. As a preliminary point, I simply reiterate that Caerphilly adopts and endorses the submissions as to legal principle made by the Secretary of State for Education and the Welsh Government, with this observation that although the authority accepts that it's under a general sufficiency duty as regards to provision of accommodation for relevant children, as provided by statute in section 75 of the Welsh Act, Caerphilly points out that it cannot ring-fence provision within its own area. And that provision was subject to the national allocation system. And so much is confirmed by the Welsh Government's written case at EF 275, paragraph 75. Caerphilly, as a local authority, with duties to protect and safeguard the welfare of children, to promote and safeguard the welfare of children, Caerphilly is willing to be guided on issues of principle and approach. However, our overarching submission would be this, that it's of fundamental importance that the flexibility of the inherent jurisdiction, which permits design of creative solutions for children and young people with complex needs, is preserved in those children's best interests in accordance with the statutory duties and the UNCRC. And on this, we agree with what the ALC says in their written case at paragraph 54, EF 327. We further endorse, so I'll come back to this, the detailed safeguards identified by the ALC at paragraph 42, EF 320 to 323 of their written case in the exercise of the inherent jurisdiction. The next point I wanted to make on behalf of Caerphilly was that in this case, this appellant was front and centre of all decision making, and her complex needs at the very top end of complexity that this local authority has addressed, which, together with the very serious risk of harm set out in the chronology and in the statement of facts and issues, and the very difficult history of failed placements, made the provision of a placement for the appellant intensely difficult, and that on the evidence in this case, that was plainly at the forefront of the care planning and of the engagement with the appellant. The appellant's welfare and safety, her right to be protected from harm, was constantly being balanced against her growing independence and increasing maturity and developing autonomy, all being finally calibrated and reviewed again.
I think perhaps, Miss Weston, it would be important to say at this stage that from what I've been reading, this seems to have been something of a success story in the end for the appellant, for T, who's done extremely well since the events that we're hearing about now.
One hesitates to use the term success story because the Caerphilly is intensely aware that that's been a partnership, that having the appellant, it's not the Caerphilly's success.
No, I wasn't.
It's the appellant's success.
I wasn't wanting really to congratulate the local authority so much as to reflect here so that we can all recognise it, how she's succeeded.
She has, and we would endorse the court's observation.
Thank you.
So we would endorse and adopt what the Welsh Government's submissions have to say about the particularly Welsh character to the framework guidance, and in particular good practice adopted by Caerphilly. It's difficult to explain in the context of this legal argument the difference that makes in practical terms, but I can highlight a couple of examples. One, for instance, in the Welsh child looked after review process, older children are invited to the meeting, and it's anticipated that they will attend throughout. So rather than leave at the point that the decision's made. So the child in the CLA process, or the young person, commensurate with their maturity and understanding, is encouraged to take part in a holistic decision-making process and to learn negotiation skills, which Caerphilly says that have stood this appellant in good stead, because she has developed the ability to negotiate successfully, effectively and articulately with Caerphilly in all aspects of her care and support. And indeed, that continues now, because the appellant remains supported under the leaving care provisions of the Act. So we contrast that with the normal practice in England, which is that the decision-making part of the LAC process, the child is usually absent. It's also, in our respectful submission, important to recall that the appropriateness of placements will be governed by very many factors indeed. And this harks back to the general submission I made about the importance of tailoring the accommodation to the child and not the other way around. That is that there's a multiplicity of factors which can have a direct bearing on the success or failure of a placement. And the failure of a placement is to be avoided because it is in itself a harmful experience for the child. So it's not just the child's needs, the particular facilities and location of accommodation, but also, for example, other children's needs that may already be accommodated in such placements, as well as the willingness and ability of secure accommodation providers to meet the need for bespoke placements, bespoke arrangements. To that end, we particularly endorse what the Children's Commissioner says at paragraph 10 of her submissions. While we couldn't possibly support a counsel of perfection in the placing of children and young people with complex needs, experienced children's social work teams, such as the Caerphilly team is, know that these factors can mean the difference between success or failure of a placement, and that failure is harmful. And sometimes, increasingly, a creative solution is what the child needs. Now, I had prepared a short submission on what Caerphilly understood the two placements to be at the material time, and it's our submission. I don't know if it's worth just turning up the Appendix Part 2 care plan and the contract so that the court can see what the arrangements were. I see Lord Stevens nodding. I take that as encouragement. It's in the Appendix 2, we see attached to the statement at beginning at 780, EF 780, we can see the care plan begins. Now, it's fair to say that that was the care plan presented in 2017, at the point at which, although Caerphilly had decided that a bespoke placement was going to be necessary, the particular arrangements that are foreseen in this care plan were rejected by the Welsh Government and therefore could not be proceeded with. However, the needs sections of the provision sections of the care plan remain relevant, and were indeed, with some amendments by way of social work statements, the needs and proposals which were under consideration by Mostyn J when he made the orders he did. We can see, without going through the care plan in details, I know that my ladies, my lords will look at it, but it's important to show there's some density of provision here, and from a multiplicity of providers, including therapeutic input, but also the arrangements for a tutor, educational provision. It's a comprehensive document. As regards the contract, which begins at 798, we can see in that document that as far as Caerphilly was concerned, its designation was, and we can see that in the first box halfway down the page at 798, that it was a specialist placement, non-regulated. So that was what the so that meant that, for instance, the fact that it was unregulated had to be brought to the attention of the court, so the court understood what the position was, and also to the attention of the Welsh Government when in respect of the non-regulation. A different question is, and which has been raised earlier, is whether the particularly firstly the Serenity placement was a children's home. We accept that it met the definition of a children's home for the purposes of the Care Standards Act. For that reason, it was required to be registered, and therefore the fact that the application for registration had been made was communicated to the court, and as the chronology makes clear, the Caerphilly chased the outcome of that application. But we accept that for the duration of the placement, that was a placement in an unregistered children's home. As regards the arrangements for the...
Ms. Weston, I
yes.
think Lord Stevens has got a question.
Sorry.
I was just wondering whether you come across any other circumstance in which the inherent jurisdiction is used in such a way as to permit somebody or authorize somebody to commit a criminal offence.
No, it's clear that the circumstances in which the court exercises inherent jurisdiction means that there's that circumstance is one in which the provider, not the local authority, is at risk of prosecution if it continues to offer that service. But in those circumstances where the practice of the registration of the overseeing body, in that case Ofsted or the CQC, is wholly outside the, whether a decision whether to prosecute is wholly outside the gift of the local authority. The local authority has to proceed on the basis that if the court gives its authorization, notwithstanding the possible consequences for the provider, that does not render, that renders the local authority's decision to place there lawful.
Thank you.
One of the reasons why the local authority is put in that position is because the local authority knows that the overseeing bodies have a discretion whether to prosecute or not. And indeed, as we've seen from the other submissions, in some cases, the overseeing body indicates that it's not going to take any action. And it's on that basis that the placements are able to proceed. Whether that's a satisfactory arrangement is not within the gift of the local authority. The local authority has primary duties to the child to secure a placement, and it does so by presenting to the court all the factors, including the fact of that a proposed placement is not registered, and the court makes a decision in its jurisdiction, which is a protective one akin to wardship. The circumstances in which the overseeing bodies may or may not have policies of enforcing or prosecuting offences is completely outside the control of the local authority. It's just as a sort of a postscript. It's inescapable that there are going to be placements which are much better suited to the child and are in the child's best interests, which are not registered, and there are going to be registered placements which are wholly unsuited to the child, and it would not be in that child's best interest to be placed there under the current scheme. Just as an illustration of why secure accommodation may not be appropriate and wasn't appropriate in this case, when I say secure accommodation, I mean secure accommodation as understood by the secure accommodation estate, illustrations of which are contained in the Secretary of State's written case at paragraph 45, EF 348, and in the ALC's written case at paragraphs 12 to 17, EF 306 to 308. They've been described by Caerphilly's witness, Mr. Jenkins, as having a punitive element, or by Hayden J in the case relied on by the ALC in its written submissions as having a custodial quality. But in any event, that those features of what is normally understood by the term secure accommodation may be wholly inappropriate for a person with complex needs such as the appellant. It's important to recall that, notwithstanding the breakdown of the placement at Serenity, in Rowan House, by the time the placement had been authorised there by Mostyn J, again, this is a house in the residential street, providing residential care for up to 4 young people. And in that placement, the appellant's freedoms increased. She went to joined Army Cadets, that she enjoyed swimming, she had timeouts, unsupervised time, went on holiday with her boyfriend, had overnight stays away, all graduated over a period of time. And there were also a number of absconsions from that accommodation, and that's set out without going to them in detail in the chronology. at this stage, bearing in mind the time, I was going to turn to what the judge, Mr. Justice Mostyn, decided in this case. That's already been dealt with in some detail by Mr. Hopkins for the Welsh Government. First of all, I would point out, in response to an observation by my Lord Lloyd-Jones, that there was not an application for Section 125 or 119 accommodation in this case. The application was squarely for the invocation of the inherent jurisdiction, because by then, for the reasons set out in Mr. Jenkins' statements, it was quite clear that a bespoke placement was going to be necessary, and it was going to be necessary to seek the court's authorisation for restrictions of liberty within the terms of the care plan. Even though a placement of secure accommodation was not contemplated. So, in response to Mr. Toomey's submissions, or submissions about, I paraphrase, but basically a blank cheque being given by the judge to Caerphilly in respect of the authorisation for deprivation of liberty, it's quite clear, without going back to it, from the terms of the order itself, but also from the terms of the judgment, that the order was time limited, it was subject to review, and in any event, the local authority repeatedly brought it back before the judge when there were material difficulties or changes of circumstance. It's quite clear that the court was concerned that the order be proportionate, time limited, and in accordance with the care plan. And so, in my respectful submission, there were square limits placed on the exercise of the how to deprive the appellant of her liberty within the placements. On the question, if I could turn then to the question of consent, we do adopt the legal submissions of the Secretary of State and the Welsh Government on the role and meaning of consent. And we, of course, accept, and I think we're chiming with the submissions of Mr. Hopkins, that the extent to which a child is able to and does give her consent to restrictions on her liberty will always be relevant to the overall assessment of whether it's necessary and proportionate to make an order authorising a deprivation of her liberty. But we say Mostyn J was right to hold, for the reasons given by him, that the consent given in this case, taken with the appellant's conduct, was properly rejected by him. And so then, just briefly in summary, while Caerphilly accepts the wider concerns expressed in particular by the ALC and the Children's Commissioner about the working of the statutory scheme, it simply doesn't recognise the description of a, inverted commas, lost child as act for this appellant, owing to the frequent reviews. These would have been the DOLS reviews and the CLA reviews. They are listed almost comprehensively in the chronology which is appended to the Statement of Facts and Issues. Plus the appointment of the independent reviewing officer, the guardian, the fact that the appellant was made a party to proceedings, and that the appellant was and is in frequent direct telephone contact with her social worker and has access to her team, and has been very involved in negotiating changes to the care plan and negotiating additional support. For all those reasons, we say that this is not an illustrative example of, or an example which chimes with the real problems that other judges in the family division have properly noted as regards the lack of availability of sufficient numbers of secure accommodation. Again, I reiterate the cleft stick that Caerphilly finds themselves in, because notwithstanding the provision of secure accommodation, if and to the extent that that is commissioned by local authorities pursuant to its sufficiency test, there is then no control over how those placements are filled as it goes into the national mechanism. That is really a matter for central government. The court's powers, we say, under the inherent jurisdiction, do extend to a power to authorise a deprivation of liberty in an unregulated children's home, where the court is satisfied that there is sufficient oversight and safeguards and registration is pending. And we say that the President's guidance, articulated by, in detail by Baker J in the B case, do provide sufficient oversight and both procedural and substantive safeguards to make the authorisation of a deprivation of those of liberty in accordance with the procedure prescribed by law for the purposes of Article 5.1. And we say, moreover, that those safeguards and the steps taken illustrated as necessary, both by the Children's Commissioner, the President's guidance, the ALC, and in Lord Justice Baker in Re B, are effectively what Caerphilly did in this case. Ultimately, like any parent meeting a child's need and right to be protected from harm may mean standing between that child and the consequences of the decisions she believes she has the right to take. But a child should not be fixed with the possibly lifelong consequences of bad decisions which put her at risk of exploitation and abuse and serious harm. These are not lifestyle choices. Where that intervention requires physical confinement, the law places limits on the state use of such powers, compliance with which is overseen by the process of seeking the authorisation of the court. And for all those reasons, we say that Mostyn J was right to make the orders he did and acted lawfully within his powers.
Thank you very much indeed, Mrs. Weston. I'll just see if anybody else has got any questions for you. No, I don't think so. Thank you very much indeed. So that will be a convenient moment, I think, for us all to take a short break, and we'll come back at noon. Thank you very much indeed. We'll resume now. So I think that it is back to you, Mr. Toomey, for your reply, please.
Well, I'm very grateful. Thank you. I'll start, if I may, with a few matters in respect of each ground by way of reply before concluding with some general comments. But by opening this reply, there has been a significant mention of bespoke placements in other submissions. And of course, the first placement on the local authority's own account was extremely concerning and failed the appellant. And you, my ladies, my lords, will have seen the recent witness statement, which demonstrates how this was somebody running a fleet of cars given short notice to find accommodation in which the appellant could be deprived of her liberty. The court might find this very concerning. And of course, the Ofsted Chief Inspector has recently reported to the Secretary of State about some of the deficiencies in unregulated placements. Ladies and lords, that is not in the papers before us, but if I may be forgiven for reading a short paragraph, and we can provide the report of the Chief Inspector to the court, but it is simply paragraph 45 of that report of January of this year, which illuminates the concerns that arose in this case and have arisen in many. Alongside these homes, that is, unregistered children's homes, we believe that a small number of companies are purposely setting up short-term arrangements as a way to avoid registering as children's homes. This may be a form of deliberate gaming, and these are some of the settings that we continue to address. Can I now turn to, firstly, in respect to the Secretary of State submissions under our ground 1A, and look at the wording of section 102D. The Secretary of State asserts that what is happening is, in these cases, the court is authorising what the local authority already has the power to do by way of its parental responsibility. We say 2 points. Firstly, no, that cannot be right. As an emanation of the state, the local authority cannot do that. But secondly, of course, in certain cases where children are accommodated, the local authority has no parental responsibility. The local authority only has parental responsibility where a care order is made, as it was in this case, of course. But there will be other cases where, by dint of the absence of the parents who could not agree to delegation of their parental responsibility because they've been lost or they passed away, and in other cases where there's a delegation by way of a voluntary arrangement, then local authorities will be accommodating children without parental responsibility. The Secretary of State says that what the local authority is doing is not in connection with any aspect of parental responsibility for a child, as the court is authorising the confinement, and took the court to the former President's draft order in AF. But in our submission, that entirely ignores the fact that the local authority is granted the discretions on a day-to-day basis. It operates a discretion as to whether or not to place the child in the accommodation restricting liberty pursuant to the permission it's been given. If it does place the child, it operates an ongoing discretion as to the extent to which the restrictive features continue to apply. That is, whether they're extended or lessened. It operates a discretion as to when to review the applicable measures. It operates a discretion as to how to review those measures, and it operates discretion as to when to bring those measures to an end. Indeed, that approach is put on a statutory framework if the child is, if his restriction is authorised by Section 25, because regulations 15 and 16 of the 1991 regulations deal with the process of review. It's a fundamental aspect, we say, of an order made under Section 25. We would also ask, if these actions are not in connection with parental responsibility, what are they? And then perhaps finally on this point, and by way of a further or more full response to my Lord Stephen's inquiry about the court oversight, we submit that the capacity of a vulnerable child, who may be very young, in state care, who is deprived of her liberty, and whose legal representation may or may not continue following the making of an order, the capacity of that child to return the matter for judicial insight is unlimited. Of course, that is limited, but that is a contrast to the position that might exist, for example, under wardship. This is not the discrete aspect of the inherent jurisdiction that we are concerned with. This is not wardship, and that oversight, by that judicial oversight, is accordingly limited. The Secretary of State's point, second point I'd like to make in respect of her submissions on this issue, it was repeatedly asserted that what is key in respect of interpretation was what Parliament intended. And we simply want to remind the court that's not quite accurate. We provided the court this morning with a copy of the Crown Secretary of State for the Environment, Transport and the Regions, ex parte Spath Holm Limited, which is a decision of the House of Lords in 2001. That might assist the court in considering the approach to statutory interpretation, in particular 388. We invite the court to consider the speech of Lord Bingham at D, just above the letter, but the overriding aim of the court must always be to give effect to the intention of Parliament as expressed in the words used. And then perhaps more helpfully at 396, speech of Lord Nichols, particularly the paragraph beginning just after F. Statutory interpretation is an exercise which requires the court to identify the meaning borne by the words in question in a particular context. The task of the court is often said to be to ascertain the intention of Parliament expressed in the language under consideration. This is correct and may be helpful so long as it's remembered that the intention of Parliament is an objective concept, not subjective. The phrase is a shorthand reference to the intention which the court reasonably imputes to Parliament in respect of the language used. It's not the subjective intention of the minister or other persons who promoted the legislation, nor is it the subjective intention of the draftsman or of individual members or even a majority of individual members of either house. these individuals will often have widely varying intentions. Their understanding of the legislation and the words used may be impressively complete or woefully inadequate. Thus, when courts say that such and such a meaning cannot be what Parliament intended, they're only saying that such words under consideration cannot reasonably be taken as used by Parliament with that meaning. As Lord Reid said, we often say that we are looking for the intention of Parliament, but that is not quite accurate. We are seeking the meaning of the words that Parliament used. We say the wording of section 102D is not ambiguous, and we invite the court to follow the plain wording, and I'll return to that if I may. Third point in relation to the Secretary of State submissions refer to the issue of Gillick competent children. Secretary of State asserts that a Gillick competent child cannot be confined. As repeated from their written case, we say this is to misunderstand how Gillick has come to be understood, and Gillick is about the child also being permitted to give a valid consent, not that the parents cannot. And that is the interpretation placed upon Gillick by Lord Donaldson in the case of Re W, and the particular passage that might assist with this is to be found at electronic 3447, starts at 3433, 3447, between letters D and E, where he said, on reflection, I regret my use in REAR of the key holder analogy because keys can lock as well as unlock. I now prefer the analogy of the legal flak jacket, which protects the doctor from claims by the litigious, whether he acquires it from the patient, who may be a minor over the age of 16, or a Gillick competent child under that age, or from another person having parental responsibilities, which include a right to consent to treatment of the minor. Anyone who gives him a flak jacket, that is, consent, may take it back. The doctor only needs one so long as he continues to have one. He has the legal right to proceed. And we remind the court that permission to appeal to the House of Lords was refused in that case, and we see that at 3463. In any event, we say the oral submissions of the Secretary of State elide, as the written submissions do, two issues: the exercise of parental responsibility and in connection with any aspect of parental responsibility of a child. And the latter is much broader. Parental responsibility has one definition. How it can be exercised depends on the child and the context. We submit that the very fact that the Secretary of State argues that Gillick, which is about parental responsibility, marks the end of confinement, demonstrates that confinement is in connection with any aspect of parental responsibility for a child. Separate issue next, if I may, the breadth of section 25. It's perhaps worth re-emphasising that we say the statutory scheme under section 25 is sufficiently broad so as to prevent children from falling through cracks. And in particular, first, we are talking about children accommodated, that is, provided for the purpose of restricting liberty. As I've mentioned, we invite the court to adopt the plain words of the statute and to apply no gloss. We wish to emphasize that we are concerned about any invitation to do otherwise. And in particular, we draw the court's attention to the definition of secure accommodation defined by Parliament. Firstly, at section 25, accommodation provided for the purpose of restricting liberty. The 1991 regulations, secure accommodation means accommodation provided for the purpose of restricting liberty. And the Welsh regulations, secure accommodation means accommodation which is provided for the purpose of restricting liberty. Secondly, a wide range of children and situations are covered by section 25. Non-local authorities, health trusts or care homes can apply under the scheme. My ladies, my lords, could I ask you to consider where that's set out in the regulations, in particular Regulation 7 at page 897. In that regulation, we see the breadth of the scope of the statute to children who are other than looked after children, accommodated by health authorities, National Health Service trusts, local authorities in the exercise of educational functions, children other than those looked after who are in care homes or independent hospitals. And pausing there, of course, the Secretary of State submissions tended to indicate that such accommodation would be hard to find in hospital settings. But the statute and the regulations made under the statute expressly envisage that there would be such situations. The Section 25(1) test is very broad. In particular, if the court is considering the alternative, Section 25(1)(b), and the mention there of the word injury, we suggest that when one appreciates that concerns about children needing to be deprived of their liberty for not meeting this test falls away. The term injury is not qualified. Interestingly, it's qualified in Section 22 as part of the local authorities' obligations, but the court is not qualified by that word. It's not qualified by the term significant. It's simply injury. Fourth, in respect of Lady Black's expressed view at paragraph 115 in Re D, we note not just that was not a concluded view, but it was expressly said not to be so. We note that Lord Justice Baker in Re D drew upon the fact that it was not a concluded view and, of course, was overturned. And we note also that where a lady refers to that, it's, and in particular, the reference to the primary purpose from the decision of Mr. Justice Wall, that follows on from a lady referring to the other scopes of accommodation, such as hospital settings, where indeed it may be difficult to tease out, as Mr. Justice Wall found it difficult, and as Mr. Justice Cazalet before him found it difficult, to tease out in a medical setting the difference. But we would certainly suggest that this court is clear in its judgment, if it agrees with our submissions, that Section 25 invites no gloss. Section 25 is clear, and Section 25 is good as it stands. It's therefore sufficiently broad to meet the needs of the children with whom we're concerned. Secretary of State then went on to say that relying on Cheshire West, we would be making the statutory scheme cover many more children than it should. But we say that entirely misses the point. Cheshire West expanded the range of people, including children, who are subject to a deprivation of liberty. There's no dispute between any party that some form of court authorization is often required for a deprivation of liberty. The Secretary of State says this should be the Crown's power exercised through High Court judges. We simply say it should be in accordance with the statutory scheme enacted by Parliament. We're not expanding the number of applications, simply correcting, we suggest, the type of applications with all the benefits that attracts, not least the fact that a High Court judge is not required or a Deputy High Court judge appropriately appointed. Rather, other judges in the family court are well placed and able to deal with Section 25 applications. This morning, the Secretary of State, we submit, betrayed a further fundamental misunderstanding of Section 25. It's about the restriction of liberty, which may not even reach the threshold of deprivation of liberty. Section 25 is not the most severe aspect of the deprivation of liberty. This difference is a central feature of domestic and European case law on Article 5. I now move on to ground 1B. The Secretary of State seems to take a complete misrepresentation of our case on the requirements of Article 5. It is not our case, as the Secretary of State said, that the inherent jurisdiction is not the law, nor that the inherent jurisdiction is not a procedure under domestic law. But with regard in particular to HL in the UK, the compliance with domestic law is just one limb. The other is the avoidance of arbitrariness. And we've set that out in our submissions on that at paragraph 73 of our written case, electronic number 194. Submissions have been advanced in relation to this ground as to the President's guidance issued in November of 2019. Can I ask the court, when looking at that guidance, to have regard to the following points? Firstly, it is not law, it is guidance. Secondly, and this appears from paragraph 19 onwards, which I think is at 5183. Forgive me, it's the next, it's 5185. So this is the guidance issued by the President to deal with the cases that arise where the home is not registered. Paragraph 19, 20 and 21 set out the guidance as to what a court should do in that situation. And it expressly invites a course to be taken, we say, or it certainly does not demur from a course being taken whereby, because it's an unregistered children's home, a criminal offence is being committed. So that's the first point about the guidance. The second point is in relation to 19 and 20, it's hard to see how in law requirements can be made of third parties, or in practice, how the requirements set out at 19 to 21 can be brought into effect. So in respect of the former, the provider must ensure that an application to Ofsted is complete. I don't know how a family court will bring that about. I don't know how the inherent jurisdiction might be employed to bring that about. And the other matters which depend upon a third party being required to do certain matters in respect of registration. And the second point, and perhaps this court will need no persuading anecdotally, that obtaining Ofsted registration is not a simple matter. These orders are made to endure for 3, 6 or longer months. It would not be surprising for an Ofsted registration to, at the timetable, to well exceed that. The child will have come and gone in the time between the orders being made, the application being sought, and the registration being granted. We hear in relation to education what Lady Arton says about the absence of facts. Of course, that is right in respect of education. Our point is set out at paragraph 67 of our written case at 1 EF 191. And of course, the court is bound by Article 51D and 51E if it applies, and the Strasbourg case law we referred to yesterday. And we will see what the Secretary of State says about that, and if we may respond. But the inherent jurisdiction or welfare are not vehicles by which those obligations can be avoided. It is a fundamental right. Moving to ground 1C, the Secretary of State asserts that little, save for a secure children's home, is likely to be secure accommodation. Firstly, that does not take account of the plain words of the statute provided for the purpose of restricting liberty. And as I say, the Secretary of State says not hospitals, but that goes against the regulations particularly relating to NHS trusts or voluntary hospitals being able to apply. The Secretary of State tells the court, and I pause to use the word astonishingly, but astonishingly we submit, that the plain words of the statute would cover the vast majority of children in children's homes. And that's simply, we say, not correct, and something extraordinary for the Secretary of State to submit to this court. Next, the Secretary of State, and the words used, withdraws a distinction between whether the primary purpose is to provide care or treatment, or if the primary purpose is to restrict liberty, with provision of care being secondary. This, we submit, entirely misapprehends the role and the power of children's services, whose role is to care for children. To be clear, this is the Secretary of State talking about children in care, subject to care orders, pursuant to care plans. Not only must they be receiving care, but if it is to be Article 5 compliant, they must also be receiving, amongst other things, educational supervision. We are not dealing with holding placements where they're locked up before they receive the care or therapy they need elsewhere. In our submission, it's troubling that the Secretary of State for Education, who's entrusted with the highest government post in respect of the care of children, makes that point. So it's no surprise, if that is the Secretary of State's view, that children are in effect in holding positions, rather like the plane circling above Heathrow Airport, waiting to come into land, and can therefore be found up and down this country and beyond, confined in caravans and holiday homes. The ruling of Mr. Justice Cobb in Ries expressed his concern that a 15-year-old girl placed with 3 members of staff in a holiday cottage earlier this year. And that is the term holding placement that was used by Mrs. Justice Judd in her recent decision of Ries. And perhaps it would assist the court to consider what, in fact, a holding placement looks like, because it was spelt out by Mrs. Justice Judd in that case. The authority is to be found from 3701. And that was an accommodation that was provided to the child. I think it's paragraph 11, the local authority proposals. The end of the placement should have come about by last week, but the unit has permitted an extension of a few days. So she was in an acceptable unit. This has now almost come to an end. The local authorities come to the conclusion that the only possible contingency plan is to place her in a council home rented by them, together with 4 members of staff who are available to care for and contain Z at all times. The restrictions the local authority asked the court to sanction are set out in the statement. The proposal is that Z is not allowed out at all, save for appointments, when there will be an escort of 3 staff. Z is to be locked into a bedroom at night, and the house be locked at all times. Should be stripped of all loose items and restrained in the event of self-harm being attempted or attempts to harm others or to escape. All furniture in each room will be secured to the floor or the wall. There is no doubt that these are draconian restrictions, and this can be no more than a holding position until a suitable placement becomes available. There is no provision here for education or therapeutic support, although a plan is to be drawn up in the next 4 weeks. The local authority does not pretend that this proposal is anything approaching ideal for Z, but they find themselves simply unable to identify any other placement. Is that the holding position the Secretary of State is referring to when inviting this court to take the narrow construction of the statute and to look for the primary purpose as being simply that to restrict liberty, with the provision of care being secondary? The Secretary of State's case, more generally, is in effect that the sole bar on the use of the inherent jurisdiction is that to be found in Section 100 of the Children Act, and that beyond that, the Children Act can be cut across as much as may be desired. So we ask rhetorically, but importantly, what is the purpose of Section 25 if in fact the respondents are right that the court can always make an order restricting the child's liberty based only on the threshold of significant harm in Section 104B and the child's welfare? It's also worth saying a few words, if I may, about the Secretary of State's submissions in relation to the Scottish case, the former President, Sir James Mumby. And in particular, of course, that was a case which was, by its definition, not cutting across the scheme, because the statute did not permit for accommodation in Scotland. Scotland was not part of the scheme. It was therefore not cutting across it. It did, of course, infringe on our first submission, I should say, that of Section 102D, but that wasn't considered in that case. But what was considered in that case, at paragraph 43, are the cases to which I referred earlier, the difficult cases, received by Mr. Justice Wall, and then Re-B, His Honour Judge Wildblood QC, and then the decision of Mr. Justice Key, and we've addressed those in our submissions. But furthermore, in respect of the Secretary of State's argument that the court has the ability to access the inherent jurisdiction pursuant to Section 104A, I'd say this. If a Section 25 order can be obtained because of a lack of registered children's homes or Secretary of State approved secure accommodation, and if this is a passport, as it were, to Section 104A, then 104A reads, the result which the local authority wished to achieve could not be achieved through the making of an order of a kind to which Section 105 applies. And forgive me, I should perhaps take you to the statute when I make these submissions. So Section 100 in our papers is at 869. So 104A and then 105A, this subsection applies to any order made otherwise than the exercise of the court's inherent jurisdiction. So the first question, is there a remedy under the Children Act? The answer is yes. Could it be granted by the vires of the Section 25 order? The answer is yes. Would it be granted if no registered children's home or Secretary of State approved secure accommodation was available? Answer, no. And so the Secretary of State is using the word could in Section 104A as if it bore the same meaning as would. The word would extends to questions of availability of appropriate accommodation. The word could doesn't. It only applies to the technical availability of the statutory remedy. And the blurring of the difference between would and could has much in common with the blurring of the Secretary of State's case between a gap in the legislation and a gap in the provision. My ladies, my lords, in the recent judgment that was sent to the court, Lancashire County Council and G, sent by the Children's Commissioner, I believe, the day before this hearing began, decision of Mr. Justice MacDonald, we learned that he became the 4th High Court judge to send a copy of their judgment to the Secretary of State concerning the lack of secure accommodation for a vulnerable young person. In July, Mrs. Justice Judd, in the case to which I've just taken you, heard from the Department of Education and was told that nothing could be done. The local authority would have to keep on searching. And that came less than 3 months after the judgment of Mr. Justice Cobb in Ries concerning the 15-year-old in the holiday cottage. And a week later, Judge Dancy in Dorset County Council and E 2020 EWHC 1098, sitting as a High Court judge, simply observed at the conclusion of his judgment that I direct this judgment to be sent to the Secretary of State for Education and to the Children's Commissioner. This, of course, follows, in this particular case, the concerns expressed by the President of the Family Division. And then in Re B, Lord Justice Baker observed that in the 12 months since this case was decided in the Court of Appeal, there has been no improvement in the provision of approved secure accommodation. On the contrary, the position seems in some respects to become worse. And so it is not only the profoundly unsatisfactory nature of the current state of affairs, it's not only the fact that these might ever be regarded as the equivalent of secure accommodation when there is in fact no equivalence. It's not only the fact that the situation is worsening. It's not only the fact that the Secretary of State, but for a consultation, appears immune to the entreaties of not 1 but 4 judges sitting in the High Court this year alone, but that it's left to the courts to act as the conscience of the nation, and to have to do so whilst exercising a welfare jurisdiction. In our submission, this court should not tolerate the position any further. It calls for a significant answer. It calls for the Secretary of State now to do what he was surely expected to do when the legislation came into effect, to provide more and more varied placements. At each of these placements is a child, a young person, typically with profound difficulties and vulnerabilities, often as a consequence of what has been done to them. This appeal calls for an answer that respects the infinite dignity of each of them. My ladies, my lords, those are my submissions in reply, unless I can assist the court further.
Thank you very much, Mr. Toomey. I'll just see if anybody has any questions that they want to put to you. No, I think we've covered the ground. Thank you very much indeed. So that leaves Ms. Clement wishing to put in some written submissions, and you're all going to talk about how they are responded to. As I said, wasn't an open invitation, but just as a matter of practicality. And I'm sure everybody will be very responsible about that. Apart from that, unless there's anything else that needs to be raised with the court, no. That concludes matters, but we must express our gratitude for all the assistance that we've had in the various submissions that have been made, and also from the interveners. And of course, I'm very conscious that in these arrangements that we're having to use at the moment, we don't see everybody who assists in the preparation and presentation of a case, but their input is very much valued, and can I express the thanks of the court for it. Thank you all very much indeed.
Thank you, Melanie.